Listen up. The laws concerning drunk driving may be changing all across the nation, and they could affect you right here at home. Here's something you may need to know before you hit the bottle and then hit the road next time. Here to explain those changes is the law forensic science lawyer Anne-Marie Rizzo from the Law Place. We are so proud of you, a forensic science attorney.
Yes.
So you know all about drunk driving. From defending drunk driving.
Well, I used to prosecute it, actually,
Oh,
and then
really?
now I'm on the defense side, so I've done both sides.
You know both sides
Yes,
then.
I
As
know
long
both
as it's
sides.
not from being in the experience.
That's right.
Absolutely. She knows enough about the consequences not to do that. So what are the changes coming up?
Well, on Thursday, this past Thursday, there was a Supreme Court ruling, the United States Supreme Court, not our Florida Supreme Court, that affected DUI cases nationwide. It's a very relevant issue across the states, and that's why the Supreme Court took on this case and made this ruling. What it ultimately said is that any time that a law enforcement officer wants to take someone's blood for DUI purposes to determine their alcohol content, they are required to get a warrant. They can voluntarily submit a person by simply, will you give a blood test? If the person says no or has any hesitation, the cops are required to get a warrant. Currently in Florida, prior to that ruling, anytime there was serious injury or there was a death, they could force that blood draw. But now, that's not the case. The Supreme Court said they must get a warrant.
But won't they be sober? The alcohol be out of their blood by the time they get the warrant?
Well, you're like our prosecutors. That's exactly what they argued. No, I mean, that is what they argued, but what the Supreme Court said is that our Fourth Amendment constitutional rights for unreasonable search and seizures still takes precedence over that.
And that
they
does
still
seem
need a warrant.
unreasonable.
Well, they can still use the breathalyzer test.
They could still use a breathalyzer, and that's the other part of the ruling. The ruling says that they can get a breath test without a warrant. And that's still what they do right now. Technically, it's a search incident to arrest is what they're calling it, and that they can still request a breath test, and they don't need a warrant for that.
But people do refuse,
Yeah,
right? People refuse.
The breath test.
So that's a great question too. So in Florida, obviously we know as we sign for our license, you're giving implied consent to give a breath test once you've been arrested. That still stands. So if you refuse a breathalyzer, there are consequences with regard to your driving privileges. Now, the Supreme Court ruling also said that if you refuse, the states can criminalize the refusal itself. So then you're not only charged with DUI, but you're charged with refusing a breath test.
Is that new?
That is not in the state of Florida. Other
Okay.
states do that. Now, Florida will criminalize it if it's your second time refusing it. And that's where the laws get a little more complex and why you definitely need a lawyer in
Right.
circumstances
Yeah.
like that, because you can't always just refuse without a consequence criminally in Florida. But there are a lot of different things that you have to go through and complexities of the law.
What can be your excuse for refusing? Because the only reason you would refuse is technically you're probably going to get caught being drunk.
Well, and that's another great prosecutor argument. That's what they say. It's a consciousness of guilt. However, as a defense attorney, those machines aren't always reliable. In my opinion, it's a machine. It's subject to error just like any other machine. We all have to reset our phones more often than we expect. And that's the same thing with these machines. And you know, you can't completely put your whole life into this machine. And some people just don't have that trust. And they would rather consult with a lawyer first. And they want to know, what are my best options, what are the consequences, and weigh those options out before they make that decision. And a lot of times they don't have that lawyer available when they make that decision, so they refuse.
Here's your best option. If you're going to drink, don't drive.
Absolutely. So when do the changes that the Supreme Court came down with last week actually go into effect?
But it's immediate. So
Okay.
for instance, I have a large, big case tomorrow where I'm going to be arguing an issue with regard to the breathalyzer, and then on Friday with regard to a blood test. In this particular case, there was both. So I'll be utilizing this Supreme Court ruling and trying to persuade the judge to rule in my favor.
All right.
Good
Good luck.
For more information or for help with a DUI case, you can contact Anne-Marie at thelawplace.com. And coming up next, Candace is going to give us a scoop on new development.
Yes, I am.
Thank you, Anne-Marie. That's fascinating.
you.